Good morning. This is the New York City Board of Standards and Appeals public hearing for January 30th, 2015. We'll begin with a special order calendar, decision items. Item number 1, 7/17/28 BZ, 5258 East 87th Street, Manhattan.
For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Continued hearing items. Item number 2, 19502 BZ, 2797 Linden Boulevard, Brooklyn.
Good morning, Chairwoman Perlmutter and Commissioners. Jonathan Mason here on behalf of the applicant. Jeffrey Chester unfortunately couldn't be here today, so he's asked me to stand in for him.
There were questions.
Yes, in terms of the 24 hours of operation, we would like to know how the board advises that we advise the neighbors of the proposed time change.
So that is the proposed time change?
Yes, the hours of operation are important to the business because a lot of the business, especially on the weekends, comes late at night. The Cineplex down the street has shows that lets out as late as 2 a.m., and most of the other competitors in that area are open 24 hours as well. So that would be something that would be very important to the business.
Okay. So, I mean, actually, this is probably something that you could speak about with your project manager and
Okay.
get into the details about
Okay.
exactly how to notify the neighbors, but...
Will do.
Okay.
And I believe the next question was about the measurement of noise from the menu board to the residents. We're actually speaking to the supplier right now to get specs on the menu board in terms of like decibels. But we can tell you that the volume is variable and it can be turned down later in the evening when ambient noise from things like traffic subside. So we've never received a noise complaint in the last 12 years, but I do think the volume is variable.
But you find out if it's variable manually or automatically? That's important.
That I'm not entirely sure.
Yeah.
But like I said, I hope that'll be part of the information that the supplier returns to us with.
Okay, more than hope, get that
Yes,
information?
absolutely.
And then the other thing that's very useful is the distance from the menu board to the property line where the residential properties are. Find out from the manufacturer what the decibel level is at that distance.
So the decibel level at the distance
Right, it
from the menu board to the
reduces-
property line?
exactly.
Okay,
It
so measure the
reduces
distance and then measure the sound at that point?
Correct.
Okay, no problem. And then also, I think there was a question about the 10-year term. And I spoke to Jeff about that, and he mentioned that at the last hearing, I think the request for elimination of term was actually withdrawn. So I'm not sure that's an issue for us any
I'm not
longer.
sure that, I didn't know that it was withdrawn.
Yeah.
Okay.
That's what I was told.
So maybe you could, if you could amend your statement of
Okay.
facts to
Will do.
eliminate that. And any place else where it mentions the extension of the term, make those changes.
Absolutely. And then after that, I think the question was menu board attenuation. And there I had a question about whether it was noise or light that we were talking about. Is it a question about noise like we were talking about before?
It's the same issue.
Okay, same
Yeah.
issue. All right, great.
Why, is it really a bright menu board?
No, I just, I actually watched the video of the executive hearing yesterday, and I just thought it had come up again later.
Okay.
And then in terms of community board approval, I was in touch with the community board, and they did approve, I believe, in February of last year, and they actually faxed a copy of that approval to our office yesterday, but it was too late for me to bring it with me today.
Okay.
So we can submit that as well.
So that was in 2014?
Yes.
Okay. Okay. All right, so you need some time to get your specifications and so on?
Yeah, I think so, maybe about 3 weeks.
3 weeks, okay. So, what are we today? So if you could submit on the 17th of February for a hearing on March 3rd?
Okay, that sounds great. Thank you very much.
Sure.
Item number 3, 7612 BZ, 148 Norfolk Street, Brooklyn.
Just 1 second, please.
Anyone here?
Okay, sorry. I think there was a request to adjourn this with a submission date on January 20th. Maybe too late for this.
I believe they've submitted it already.
They submitted? Okay, so
But
here.
it-
But it was late.
It just wasn't in time for the submittal scheduled for this hearing.
Okay, so for a hearing next week then, February
Yes.
3rd. Okay.
Well, actually, no, I thought we said we're going to have it, I think it's on the 10th. I have it written down that it's continuing, oh, the 3rd, it's,
That's what was requested, but the
We said we would work it out with council, but I don't see.
Yeah.
Yeah.
So actually though, because that's just next week and I haven't seen the submittal, maybe we move that, we say the 10th. Yeah, okay.
Okay, so February 10th is the
February
hearing date?
10th for the hearing.
Okay. Appeals calendar, decision items, item number 4, 66539A and 10714A, 5557 West 44th Street, Manhattan.
Good morning, Melanie Saddock on behalf of Fox Rothschild and the applicant.
Good morning. For a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
aye.
Commissioner Otley Brown?
Aye.
Thank you all very much.
Thank you.
Item number 5, 11014A through 11214A, Roswell Avenue, Staten Island.
Good morning, Todd Dale for the applicants.
Okay, we're good with the fire department's review, right?
Yes.
So then for a motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Hinkson?
Aye.
Commissioner Montanez?
Aye.
Commissioner Otley Brown?
Aye.
Thank you.
Thank you.
Continuing hearing items, item number 6, 27813A, 121 Varick Street, Manhattan.
Good morning. Stuart Beckerman, Slater and Beckerman for the appellant. We attended review session on Monday, and again, I just want to first thank the board for going through our papers and reading them and thinking about them. It's much appreciated by me and my client and our team. Before I go through some of the questions that were raised and sort of restate some of our positions, I just want to give credit to my co-counsel, Isaac Spilsinger, who really, he sort of came up with this legal theory. He's not a zoning lawyer, so he has the benefit of sort of looking at things outside the weeds, as we zoning lawyers do. So I just want to thank him for that, because he sort of gave us his theory, and he provided us with much of the research. And so it's really nice to see that the board is responding, and the arguments are gaining some resonance. So before I respond to each of the questions directly, I just want to say that, you know, in responding to the questions, I think we're always going to sort of go back to the statute. Section 4255, which provides that for purposes of that section, arterial highways shall include all highways that are, 1, shown on the master plan of arterial highways and major streets as principal routes, parkways, or toll crossings, and 2, have been designated by the City Planning Commission as arterial highways to which the provisions of this section shall apply. And the master plan list amended in 63 shows a Holland Tunnel as an arterial highway, and it's represented, as has been stated over and over again, as a series of dots ending at the Miller Highway on the New York side. And according to the legends, the dots indicate that the particular arterial highway is a toll crossing under an authority. The Holland Tunnel is a toll crossing under the exclusive jurisdiction of the Port Authority of New York and New Jersey. The master plan does not show any of the roadways the Buildings Department is claiming as an approach. Therefore, these roadways cannot be an arterial highway as defined by the zoning resolution. So one question that came up is the definition of tunnel. It is our view that the arterial highway is the tunnel itself, which extends from portal to portal, and the basis for this view is that the Holland Tunnel is under the exclusive jurisdiction of the Port Authority. And Section 4255, I keep returning to that section, requires that the arterial highway to which the signed regulations of the zoning resolution apply must be, quote, shown on the master plan as, in this case, a toll crossing under the jurisdiction of the Port Authority, I paraphrase. And the enabling statute for the Port Authority makes no mention of any approach to the Holland Tunnel. It does make mention of entrance and exit plazas, but it makes no mention of any approach. So therefore, for determining the tunnel, you know, the extent of the tunnel that is applicable here, we turn to the only definition of tunnel in any law, regulation, or rule of the Port Authority. And that definition of tunnel is in section 1200.3W of the Code of New York, I think it's Title 21 of the New York Code of Rules and Regulations, which provides that a tunnel, quote, shall include any tunnel within the jurisdiction of the Port Authority between the portals thereof, but shall not include the plazas, approaches, and highway connections thereto. Yes, that definition is in Article 1, which is the traffic rules, regulations, and toll rates. However, this rule is the only Port Authority provision containing a definition of tunnel. So it is really the only place that we can turn for a definition.
Can I just ask a question about
Sure.
that? So how do you, because it's in a different statute that's really about traffic, right?
Right.
How do you get from that place over to the enabling legislation? With the definition?
Well, again, only the Port Authority has that exclusive jurisdiction, and that just happens to be where the definitions are located.
Is it
I mean,
the
I can
only
sort of,
place
pardon?
where- Is that the only place where definitions are located at all in the statute?
That I know of, yes. That's the only
So maybe
definitions that we
check
could find.
that, because-
We will recheck and
Yeah.
reconfirm.
Because, you know, arguably, since that is regulating traffic.
Right.
And their domain for where they can issue a ticket, essentially, portal to portal, that kind of makes sense. And since that's not related to signs, you know, signs or not, doesn't travel along with any of the other materials that you submitted, for instance, that are contemporaneous, like in 1945, you
Right.
have the discussion of the master plan, and at the very same minute, you have a discussion of the sign regulations. You can make that link, right?
We
But-
will elaborate further and do further research, and it will be in our next brief.
Okay.
But if I may analogize, the master plan is really about a plan for highways. It's a traffic plan, but it is cross-referenced in the zoning resolution for zoning purposes. So,
Right, the master plan is, no
right,
question.
exactly. So I
But
just,
not the traffic rules.
I understand. We will explore that further and address it in our next submission. So again, in the absence of a definition anywhere else, it's reasonable to rely on this, given that this is a definition that's in a regulation promulgated by the Port Authority. And again, we'll provide a case, we actually have a case citation to support this view, and we'll provide that in our next
Is that
paper.
the case from 1956?
It's the Morelight case, which was that 19, I don't have that in front of me, but,
About when was that? Oh, that's an earlier case.
yeah, I don't think we haven't submitted that yet, but
Okay.
we will submit that in our next brief. And you also asked if the Port Authority, if those traffic regulations cross-reference the applicable statute. They do, and we'll provide the page that shows that. And they cross-reference, they talk about they reference the enabling statute that we...
Okay, to make the link.
We will make that link. So, and the chair, the board also asked about the ramp, we'll call it the ramp, to distinguish it from the other roadways leading to the Holland Tunnel, which is just north of Broome Street. And it extends from the portal to the street line of Broome Street, and whether the sign can be seen from the ramp. We have not done an authoritative, at this point, analysis. I personally went on excuse me, Google Earth, and I did the camera thing, and I looked up, and it appears that that wall is entirely obstructed by the building to the east. But regardless, we continue to hold the view that, and we respectfully argue that this question is really not relevant. The only issue is whether the ramp is an arterial highway as defined by Section 4255. It is not. It's not shown in the master plan. It, in fact, is it's not on the city map. It is shown on Block 578 as Lot 80, which is owned by the Port Authority, just as the subject roadways are on the block immediately to the south, and they are not in any way delineated as roadways or anything on the tax map.
Could we just go to something
Sure.
about that? So the enabling legislation for the Port Authority gives the Port Authority the duty to determine where approaches are and so on, right? And it also has the authority to acquire property in order to accomplish that. So how do you reconcile the fact that it acquired Lot 80 and Lot, I forget what it is, 573, Lot 1? 578, Lot 1? Like, for what purpose did it acquire that property then?
When I get into the whole issue of the history of the master plan and the fact that it's not an arterial highway, I think it's the same answer, and the fact is it's not part of the arterial highway. It was never a city planning resolution that put it on the master plan. It's just something that the Port Authority has the power to do, just as it owns Freeman Plaza and it owns St. John's Plaza, and it can do with it as it wishes, but that doesn't necessarily make those pieces of land part of the arterial highway.
Or it doesn't have to be part of the arterial highway, an approach there too, right?
But even as an approach, it has to be an arterial highway. Because the buildings department, then there's no real legal basis for making it subject to covered by 4255. You can't just simply say, based on this is what the buildings department has been doing. They promulgated a rule that we believe exceeds the statutory authority given to them under the zoning resolution because they're going beyond what the statute allows them to do. And that same reasoning applies to this piece of land as well.
So then, according to that, there isn't any such thing really as an approach,
Not for the
right?
Holland Tunnel.
No, let's just look, because you always show the images of the
Right.
Lincoln Tunnel,
Right.
and those small dots.
Correct.
But are those small dots an approach, or they're arterial, that's part of the arterial?
What happened in the zoning resolution when those words approaches were added and approaches were added? We believe that was done. I'm trying to think of the right words to use, but it didn't follow the proper procedure, and they don't have the legal effect that people are imputing to them. It was done. It was. We'll provide more documentation on that.
And just kind of as part of this analysis, this is a very fascinating
Right.
subject, so
Right.
I can't tell you how many people are involved in studying this at the board. And so there's been a lot of research done, and we found a lot of sources that have to do with the history of the Holland Tunnel. And so I encourage you and your able litigators
Right.
and co-counsel to do that same amount of intensive research on the
Okay.
history of the tunnel and to learn what they meant by approach,
Okay.
because it's actually available if you look hard enough. Okay?
Okay.
And again,
May I ask you a question? Is
Yeah.
there anyone on your staff that we can turn to who might have that information that we could?
yeah, I mean,
Okay.
you can speak to the
We can
council.
talk about-
I mean, if the
The
research has been
resources
done,
we
obviously we'd like to see
Right.
it.
And of course, with Doobie as well.
Yeah,
Yep, of
everybody,
course.
right. And so and then the other part of it is because our research is kind of limited to online research and you have much broader capabilities, as I requested before, is really to reach out to the Port Authority and to city planning and talk to them about what was going on back then.
Okay.
And, the master plan is more than just dots. There are engineers involved who must have done drawings, certainly did drawings.
Right.
Right.
But if I may, it's not just the master plan, it's what the statute says, and
Right.
it's what 4255 says. And 425, in our view, is unambiguous. So we're guided by the text of 4255, and obviously Appendix H as well, because that is the text that sort of lays out the designation process in our
So you
view.
think 4255 is unambiguous?
It doesn't have the,
Does
it
it tell you
doesn't
what to
have,
do?
if, to the extent, if it is ambiguous, I think that the buildings department is going beyond the parameters of that ambiguity, if I may.
So
So
tell
I-
me, so go through the unambiguity.
Right.
What does 4255 tell you to do?
Well, 4255 says it has to be shown on the master plan. That's clear.
Okay. And what else?
It has to be shown as a principal route, a parkway, or a toll crossing, and it has to have been designated by the City Planning Commission as an arterial highway to which the provisions of this section apply.
Okay,
And
so
then,
how would you know that?
well, Appendix H lays out, in my view, the designation process. It says pursuant to the provisions of 3266 and 4255, the City Planning Commission has designated as arterial highways to which the provisions of 3266, and 4255 apply. And we turn to the old city planning reports that talk about, where they've adopted certain roadways as arterial highways. And then it also says the following arterial highways, which appear on the city map. And again, these subject roadways do not appear on the city map and are also indicated as principal routes, parkways and toll crossings, which in this case, they do not. They are not, and are on the duly adopted master plan. So
Let me just one.
Sure.
So, though with respect to the city map, it's true, it's virtually impossible to find the Holland Tunnel at all.
Right.
Like, there's a little dot, like dashes.
Right, ends at the Miller Park.
Yeah, little, but it's subterranean, we're not going to deny that the Holland Tunnel's there, right? It's certainly shown in the master plan. So you get to that, right? You get that that's the arterial highway. So, success, check on these first 2 points that are on this Appendix C or H, depending on which year you're reading, right?
Right.
So, all right, so now you go down and then you get to Holland Tunnel, and then that word approaches. So what do I do now?
We will show you that those words and approaches don't have real meaning unless they are represented on the master plan or have been specifically, right, if they are not on the master plan. Because there are so-called approaches which do show up on the master plan, or where in the enabling statute they specifically approve approaches. And no approaches have been approved for this by the Port Authority for the Holland Tunnel.
Could I just ask, for maybe when you're providing additional information, that you clarify, you look at in Appendix H, toll crossings, and we've got an entire list of, we've got the Bayonne Bridge and approaches, and we've got Brooklyn Battery Tunnel. Maybe what you could do is lay out for us those crossings that appear here, and I guess distinguish those that show the approaches perhaps on the map, that don't show the approaches on the map, and then also distinguish whether or not they are under an authority's jurisdiction or whether they're under city jurisdiction. It might be helpful to see
Sure.
that kind of as a spreadsheet and just to
We will-
understand whether or not it's sort of an anomaly that approaches does not appear on a map. Or is it at least inform the discussion of whether that's actually an approach city planning took, not to maybe put these on a map, because maybe approaches change over time. So putting the approach on a map may be, something that they couldn't keep up with. But it would just help me to
Sure.
kind of understand.
We will do what we
If you don't
can
mind.
to address that. We will do what we can to address that. But, I will at least address one other point, just to ensure that what the board sees as an approach doesn't get out of hand. Obviously, we're pushing for a very restrictive view.
Yeah.
But I just want to take a step back and point out that the Buildings Department's view and the way they've applied Rule 49 is so far beyond what the statute allows. I just want to make that clear for the record.
Which is kind of a separate point, right?
Right, it is a separate
So
point,
first
but I
you're
want to
working
make
on approaches.
that there
Right.
has to be some legislative guidance
Right.
here. And I believe that the board, where the Buildings Department has gone, is so far beyond where the legislation could ever have taken that.
Okay, so that's what we're trying to dig at. too,
Right, I
okay?
appreciate
So,
that.
and all of this really terrific research that you've done, the reason, you can always tell a really good case because it's the one with the best information,
Yeah.
well argued and all of that. So that way, there's tons of questions.
Right.
And the bad cases, you can't really ask any questions because you don't actually know what anybody wants, right? So this is really a very well-structured argument and with lots of backup that encourages more discussion and more research. So thank you for giving us the opportunity to do this, but except for the fact that it's a very difficult question that's consumed a lot of sleepless nights on my part. So I have another question just to pick up on, so the 1945 City Planning Commission report, which discusses the master plan, so that's one of the amendments of the master plan, has a list of, this is the very, very extensive list of all of the different routes that are all over the city, right? And when it gets to the water crossings, it calls them toll crossings. And it says, this is page 115 of the 45 Master Plan Report. It says the water crossings provided as toll facilities by specially constituted authorities, which together with their approaches are essential links in the arterial highway and major street system are listed below. And then it says with respect to Holland Tunnel, this facility connects Lower Manhattan with New Jersey and also will connect with the proposed infamous, that I add, Lower Manhattan Crosstown Expressway. So there's a place in the master plan where the word approaches is used with respect to the toll crossings, right? And that's the master plan, which happens at exactly the same time as the change in the text for the sign regulations, right? So in 1945, then they changed the sign regulations to list the Holland Tunnel and its approaches. And before that, 1940, and approaches was not part of the description. It just said Holland Tunnel. So the word approaches obviously had meaning. So we shouldn't cast off approaches. Maybe it's something else, and we need to figure out what that is, right?
Right. Obviously, we wrestle with that too, but we'll answer that in our post hearing brief. Okay.
Yeah, I'm sorry. We have some more questions.
We could
so-
actually, my co-counsel, Isaac Spilsinger, would like to respond to that.
Okay. And just jump in, don't ask.
Afterwards, we have two follow-up
Sure.
questions for you.
Good morning. Can we stand here together?
sure.
Or we?
Yeah.
You can
okay.
identify.
Just state your name for the record.
My name is Isaac Spilsinger. I'm an attorney admitted in New York. I want to thank counsel here for giving me a lot of credit, but I don't think that I deserve all that credit. I believe I can answer most of your questions. I don't know whether the answers would be acceptable. Some of the answers necessarily involve, in my opinion, speculation as to what people thought or what might have been done, could have been done, should have been done. At the end of the day, it wasn't done. We have a statute which is ZR 4255 today, was ZR 4253. And I'm not a zoning lawyer, so if I misstate something, I apologize in advance for it. 4253, the section that my client is accused of being in violation of, consists of two elements linked by the word "and." The first of these two elements is the requirement that the roadway, which is alleged to be within 200 feet and within view of the advertising sign, must be an arterial highway, which is defined in 4253 in that first section. The DOB in its August 26 submission right here specifically conceded, if I can use that word, that is the definition of arterial highway. The arterial highway is defined as a roadway which is shown on the master plan as one of three categories. It's either a parkway or a toll crossing or a principal route. Now, each of these, without going off on a tangent, is fully described in the CPC reports that accompany all of the work that was going on from the time that the CPC became interested in hacking away at the entire city of New York, not only with respect to movement of traffic, but with respect to every single cause of concern for the life of the people in the city of New York. What I'm talking about is this master plan is a master plan of highways. There was a master plan for sewers, there was a master plan for schools, there was a master plan for just about everything in the city of New York. This was a time when the city was growing at a tremendous pace, and people needed to take into consideration how things were going to move as far as the master plan is concerned, how goods were going to move and how people were going to move freely in the metropolitan area in order to be able to grow as a city. In that regard, in 1939, the CPC, which had certain powers under the New York City Charter and the Board of Estimate, without getting into all the details, there were different things that each was involved in, but the master plan of highways was developed over a period of time where consideration was given to the movement of goods and people in and out of the metropolitan area, and particularly Manhattan. And the plans that were submitted for different types of highways are the subject of numerous books, which I think, the people who are doing research for you are reading. It's interesting from a certain perspective, but at the end of the day, the City Planning Commission, in its wisdom, and under Section 197 of the City Charter, conducted hearings, which they were obligated to do, and they sat down, they looked at all of these roadways, and they decided which of these roadways are going to be arterial highways. An arterial highway is not a Broome Street. How do I know it's not Broome Street? Well, because we are given a statute, ZR 4253, which the predecessor was, I think it was Article 5, Section 21B, which was first enacted in 1940, where the language of how advertising signs are going to be restricted was first proposed, was first adopted, and then from there were certain changes that were made, but the fundamental aspect of that statute was that an arterial highway was given a definition which changed a bit between 1940 and 1941, changed again in 1945. Now, between 1941 and 1945, I'm not a historian, but we all know what happened during that time. There was something called World War II. People started coming back. There was massive need for planning and doing everything that needed to be done for the post-war development. Now, during this time, and actually it started in 1927, and even before that in 1921, the federal government and the states of New York and New Jersey realized that Manhattan was a very important place and that it was the crossroads of some very, very important commerce, and they decided that there was going to be a need for certain bridges to link the eastern Long Island and Manhattan, which is obviously an island in and of itself, with Staten Island. And when looking at this entire district, created a bi-state agency, which was originally called the Port Authority, and then its name changed to the Port Authority of New York and New Jersey. It was called the Port of New York Authority. But to make a long story short, during this time frame, a number of bridges and the Holland Tunnel itself was the only tunnel that was actually built, but the bridges that were mentioned by Commissioner Hinkson, the Bayonne Bridge, the Outer Bridge Crossing, the Goethals Bridge, these are all part of this group of highways, which legislation on the federal level went back to the 1920s. They were built before the master plan was developed. In fact, by 1945, Most of the, the Lincoln, two tubes of the Lincoln Tunnel were completed. The Holland Tunnel had been completed in 1927. The George Washington Bridge, the upper level was done, the lower level wasn't, and the bus terminal still needed to be done. But when the legislation creating the bi-state agency was enacted and put into existence, the development of the Holland Tunnel was finished. It was done. Section 21B was enacted in 1940. The Holland Tunnel had existed already for 13 years by 1940. Now, CPC, they had a big job to do, and they're very intelligent people. They used the word approach numerous times in the writings that they did, but they never characterized approach as a kind of highway. And the reason that they didn't do that, and it's speculation on my part, is for the same reason that today, if you look in the Department of Transportation statutes or the vehicle and traffic law, you're not going to find in the definitions of those sections the word approach. You will also not find the word approach as a definition of a category of highway in the master plan. You will not find it there. And there's a reason why you won't find it there. The reason is that the word approach can be used as a verb, can be used as a noun. When you use it as a noun, you're calling something an approach which has been created and basically identified and given that name, okay? Otherwise, we say there's maybe an approach to a building, there's an approach to a bridge, there is an approach to a tunnel. And nobody can dispute that the use of the word approach and the common meaning of that word is that you're going towards some structure. Okay, you could be approaching home. Does that mean that that approach that you're taking to your home is an arterial highway? Of course not. An arterial highway has a definition. We are guided by 4253, 21B, whichever one you choose. The arterial highway definition hasn't really changed.
Can I ask you a question?
Yes.
Sir? Regarding this particular toll crossing, at one point there were toll booths in this plaza.
Yes.
How would you define the toll plaza where you actually pay the toll?
A toll plaza. This area got a name. It was called Freeman Plaza. The legislation, and I apologize, I am interrupting you.
No, but if there was still toll booths there, would you consider that part of the Holland Tunnel?
It is part of the Holland Tunnel. It's part of the Holland Tunnels, the definition that you see in the legislation that created all of these structures, all of these facilities, I should call them, because that's the word that's used in the statutes, are vehicular crossings. They apply whether it's a tunnel or a bridge. The Bayonne Bridge is a vehicular crossing. The Outer Bridge crossing is a vehicular crossing. They are vehicular crossings. What is a vehicular crossing? Well, because this is Port Authority of New York and New Jersey, and their legislation is what tells us what it is, we go look at the PANYNJ to see what they consider a vehicular crossing. It's theirs. Now, if we wanted to know what the Triborough Bridge and Tunnel Authority considers something, we look into TBTA statutes.
But suppose there were toll booths still there, and I look up and I see the sign. Is that permitted? In, context of the PA statutes and the zoning resolution.
Our argument,
At the toll booth.
Our argument is based on guidelines that we have from 4253. 4253 doesn't say that we need to put a person in that plaza or in that area to see if we can see the sign. That's part of within view. But before we need to, there are two elements. One is that it's got to be 200 feet within view, and there must be an arterial highway. All three must be present in order to have a violation.
Well, the approach.
Well,
What about the approach?
no, the approach, okay, is not an arterial highway unless the CPC makes it an arterial highway by putting it on the master plan.
So that's the part that I'm not quite following. The part that I follow was you talking about how bridges were built and how these tunnels were built prior to the creation of the master plan and so on. And so it's sort of city planning maybe not up with the technology or the terminology, and not realizing or not thinking about the fact that with the Holland Tunnel, everything's called a plaza, entry and exit plazas. So, and so maybe it's city planning's error by not saying with respect to the Holland Tunnel only, because the others seem to have approaches, that Holland Tunnel should have said exit and their plazas instead. However, the word approach has a capital A. It's not approach is generally kind of generic. So it's being something very specific with a title approach with respect to that tunnel. So wouldn't it be reasonable to interpret, since you don't know what to do, and you do have historical data, not to mention, like for instance, those fabulous photographs that show the little toll booths and so on, and other data that describes it as an entrance plaza, wouldn't it be reasonable to assume that that was the word approach with a capital letter?
Not to me.
Not to you, because?
No, because as a lawyer, when I don't know the answer to a question, I look in the book and I try to understand how the law tells me or guides me to be able to answer the question. In this case, or in any case where I am asked, if I went out on Broadway and somebody asked me, is Broadway an arterial highway? I would say, because now I've been involved in this, that I would say, well, you know what? We got to get the master plan, and we got to look at that to see if Broadway is an arterial highway. If the same person then asked me, is Broadway an approach? I would say, yeah, without any problem. What is it an approach to? It's an approach to Bowling Green. It's an approach to Wall Street. It's an approach anywhere you want to go. Approach is a word which we all know kind of what it means, but it's not the same everywhere.
But it's a lowercase approach. It's an approach
But
on Broadway to my house.
If it is an uppercase approach, and the only way it could become an uppercase approach is if the CPC made it an uppercase approach. It has done that. CPC has done that.
With the word approach someplace?
Well, yes. Somehow yes, it has called the Brooklyn Bridge approaches. When we look into the descriptions of different roadways, we can identify, the ramps going up to the Brooklyn Bridge. The original goal of the arterial highway system was to link everything up so that you could drive from one point to the other without getting off. And so approaches, right, which were contemplated at that time, were in the nature of connecting different highways to each other. And when you read the CPC reports regarding the different places where there are approaches and they're identified, for example, in the Staten Island with the bridges that were mentioned by Commissioner Hinkson, you can see that the linking up of the approach highways are sometimes highways themselves. The approach is a highway. Okay, but nobody, when you are driving on, for example, off the Bayonne Bridge or off the George Washington Bridge or out of the Lincoln Tunnel, you're not going to see a sign that says tunnel approach with a capital A. That's not it's not a defining characteristic of a highway. It's a common use of a term, which also has engineering applications, where people describe where certain roadways are going to be placed. Now, what happened here with this statute is that we have two elements from 4253, which the first one takes us right to the master plan just to see if it's there. This board was involved in a case in the Lincoln Tunnel case, and that's exactly what was done. How do we know there's an arterial highway? And in that Lincoln Tunnel case, the question had to do with an area that was just beyond the last of the little dots. So do we know, is it not? Let's enlarge it. Let's see. We couldn't see it from the map itself. Let's get the CPC reports. That's fine. After all is said and done, in that particular case, the DOB argued that if the roadway is part of the toll crossing, right, then we don't need to go to Rule 49, okay? So the only time you wheel out Rule 49 is when nothing else seems to work to create the arterial highway, and even that is not an arterial highway, it's an approach. My time is up. Sorry.
Could I just ask one question, though? When you answered Commissioner Montanez when she asked you what the area of the toll plaza was, did you state that was the Holland Tunnel, for your understanding?
That's part of the vehicular crossing under the definition of the Port Authority of New York and New Jersey rules and regulations.
Right.
This is land.
I just thought, did you refer to it as the Holland Tunnel? That was just my question.
It's part of the Holland Tunnel vehicular crossing. In the same way, if you look on the master plan legend and look at Rule 4253, for toll crossing, the 4253 uses just two words, toll crossing. If you look on the master plan legend, it says toll crossing under authorities. Under authorities is a recognition by the CPC that there are authorities, and there are two. At the time that this was being done, there was the New York Bridge Authority, which ultimately became the Triborough Bridge and Tunnel Authority, and the Port Authority of New York and New Jersey. New York City itself has no toll crossing. There are no New York City-owned bridges or tunnels or toll crossings.
So
It's TBTA or PANYNJ.
So the plaza,
unless
the
I'm
toll
wrong.
plaza would be considered the toll crossing under authority. The toll plaza.
Vehicular crossing. It's called a vehicular crossing.
Can you actually, because this is quite confusing and it's a new term that's being used now, can you work on this, brief this, because it's not clear what a vehicular crossing is? and
I
why-
apologize for taking...
Yeah,
Counsel,
yeah, thank you.
sorry,
I'm
Counsel,
just asking
two
the
other
question.
questions.
Could I just, I was just asking the question because I was confused because when Mr. Beckerman came up, he stated that only the Holland Tunnel portal to portal was the toll crossing. So that's why I was just asking for your
Okay.
clarification. I found that
Under the
confusing.
definitions, which are in our papers, and we'll be glad to highlight them, the vehicular crossing consists of various facilities or portions which are identified separately. Okay? There is a separate definition for tunnel, okay? And the vehicular crossing definition includes plazas and any approaches. Now, just because the word approaches is there doesn't mean there's one at the Holland Tunnel. There were approaches that were mentioned at the Lincoln Tunnel. There were approaches that were mentioned for the George Washington Bridge.
Counsel?
Yes.
So you've made this point a number of times with respect to the enabling legislation and its reference to approaches to the George Washington Bridge and the would-be Lincoln Tunnel. Can you provide, and you don't have to answer now, at some point, an index of anything that was constructed before the enabling legislation that was referenced in the enabling legislation as an approach? As you've noted, the Holland Tunnel was already constructed. These aspects, so if you could take a look, I'd like to know about that. I also...
I think all of the bridges connecting New Jersey and Staten Island.
Okay, we'd like to see that. Also, the statute also requires that the Port Authority, as it was created in the statute, indicate on maps filed with the Secretaries of States of New York and New Jersey the locations of bridges and tunnels and provide a comprehensive plan. Have you reached out to the Secretary of State of New York?
We have.
And do you have copies of those
We
maps?
have, we were referred to the Port Authority, and we were told when we put in a request for all that all of those documents were destroyed in 9/11. They were kept in the World Trade Center.
Nothing electronic, nothing?
Nothing.
Okay.
I'd just like to ask a follow-up question on the idea of the intention of putting in and approaches with a capital A into the appendix. I understand what you're saying, that perhaps it's maybe sort of a catch-all, and it may not have been intentional that there would be approaches, but I question that only because they talk about the Henry Hudson Bridge. Henry Hudson Bridge sans approach. Why? Because it's actually on the highway, right? It's the West Side Highway, or, you know, further north, it's the Henry Hudson Parkway. So it seems to me that there was intent, and that capital A does mean something, that there is something called an approach. And I guess what I'm grappling with is exactly what that is. I don't think it's necessarily something that was just a catch-all, because if it was just a catch-all, they might have said, and the Henry Hudson, you know, bridge crossing, and its approaches. You could get on Dykeman, and, you know, but the thing of it is I think that there was an intent, and I'm looking for what is an approach, so that I can make the determination whether, you know, Broome Street is an approach or not.
Okay, but no, the only way I could answer that question is by speculating myself. But what if I were to find places in the CPC reports where it's used with a small a instead of a capital A? Would that somehow?
Well, we know about those. We
No,
know
I'm
where they
talking
talk
about in a
the
name, in a
GW
name.
approaches.
Talking about in a name. Well, I understand your question to mean that the Holland Tunnel and approaches, for example, with a capital A, is a name of something.
Something.
Okay? There are other places that have that name, okay? How it came to that name, I could only speculate about that. It could have been a mistake, which nobody wants to say that it's a mistake, because somehow that's taboo. But it could have been a mistake, and it could also mean, in the context of everything that is in the CPC reports and in the painstaking process that they took to give a definition for arterial highways, and all the work that was done to understand that when it says any arterial highway, Holland Tunnel, and approaches, to mean if the approaches are in the master plan and on the city map as the designation text requires. The text of the designation is inconsistent with the addition of the words "and approaches." It's completely inconsistent. That's one of the points that we make. The text requires, the text of the designation, let's separate 4253 into two parts, the master plan and then the designation, okay? So let's finish with part one, and then there's "and," right? That the CPC designated, right, that the roadway as an arterial highway, right? So we look at the designation. The designation, when you read it, it says that, first of all, it includes the master plan, and then it adds the city map. Now, you look at the list, and you see things in the list, and specifically the Holland Tunnel. I'm not going to comment on anything else in there. It says Holland Tunnel and approaches. Where did this come from? And approaches. It's not on the city map. We don't see any approaches on the city map. Okay? So did somebody have something in mind? Maybe they did. Did somebody put something in thinking that maybe when they finish with this midtown, this highway, that it was going to be there? That's probably what they had in mind, as far as my understanding is concerned. But it was never taken out when the highway wasn't built. There are things that were left in. There are statutes that are left the way it is. This is a very, very, very complicated thing. But how could it be? How could it be after all the work that the CPC did over years and years, and doing this master plan map and adding roadways and sitting down, having hearings and having everybody come in and testify and all of that, that you can come in and add 2 words, and approaches, and you got an arterial highway. It cannot be. This cannot be.
Can I just ask one last question, and I think then and then council has some questions too. So, the word vehicular crossing is kind of a new one in the conversation, and I see where it is. It's right underneath the definition of tunnel here. So, just a second. So, vehicular crossings, I just, for the benefit of everybody who doesn't have this statute in front of them, this is in the Port Authorities, again, the rules that have to do with traffic. So, I'm not even sure relevant, but let's just say. So, the word is used, vehicular crossings shall include the bridges and tunnels and the plazas, entrance, exit plazas, approaches, which are distinct from plazas, and highway connections thereto within the jurisdiction of the Port Authority. So I guess my question is, do you think that if 4253 had just used the word vehicular crossings instead of arterial highways in here, we'd be done? We'd be clear?
If I may, Madam Chair, it did not, though. That's the thing. And I'm a little concerned that this term, vehicular crossings, has now entered the debate because it's a complete distraction. It is not a term that we're looking at. It is not an arterial highway. It is not a toll crossing it is not any of that. And so I'm a little concerned that it's become a little distraction.
Well, but it's relevant because we're struggling with the fact that things are called exit and entry plazas. What are those things?
Exactly. And let me just finish what I wanted to say. As you had pointed, as the board had mentioned and clearly stated in review session, the zoning resolution needs to give clear and reliable notice to property owners. If we were to take this definition of vehicular crossing and suddenly allow the building, that to be the basis for any future regulation, that's dangerous because, as the buildings department pointed out, they could, a roadway can change within an hour, and then what does that mean for a property owner who's seeking a permit and then obtaining one and relying on it? And, the whole history of this plaza, this entrance plaza, I think helps make our point that that should not be an approach because it could change in an instant. It is no longer an entrance plaza. I mean, there's no longer a toll there. So, the road system is completely changing. It can change again by the end of the day. You've got police stationed on Broome Street. That can change too, and that also affects whether it even meets the definition of an approach under Rule 49. So I just think that needs to guide us. We all know, the case law that zoning needs to be, if there is an ambiguity, it needs to be interpreted against the drafter in favor of the property owner. So I think that always has to be in our minds as we look at this. We will address all these issues. We will clarify these terms. We will, look at, we will, sort of research and advise on the history of the term and approaches, where that came from. What I've seen on that, I think, should be helpful to the board, but all it does, it kind of contributes to the confusion and the ambiguity, which I think further supports our position.
We just want to reference for council and also council from DOB, a publication called The Eighth Wonder of the World. I believe you actually were paraphrasing sections of it, sir. It was published in 1927, and we think that it should inform the next round of submissions from both sides.
And right, with respect to that, the word approach is used and kind of clearly defined. And so the question with respect to that is, that was what it was in 1927. We don't know if that's what it was in 1940 or 45 or 98, right? So that's another part of the discussion.
It's difficult to get a copy of, contact me and I'll help you.
Great.
Okay.
And then, but just, I actually think the vehicular crossings being brought into this, if we accept the idea that you can use definitions from this set of rules to import into a statute, I'm not even sure that you can, but if we accepted that, I think it actually is informative because it distinguishes plazas from approaches. and puts them under some other kind of term, though the word arterial highway isn't at all mentioned here, but it also distinguishes it from a tunnel, clearly.
I see.
So I don't think bringing it up hurts you.
Right.
I think it helps
Right.
us study, and to try to get to the bottom.
We have actually, I think, said that in our papers, but we will bring that out and sort of make it more prominent.
Okay. Okay. Did you have something else?
Just one final point for really both sides. To the extent that your interpretation is or is not in furtherance of what you understand to be the purposes of the arterial sign regulations, that should be part of your discussion. So when you go through and look at and approaches, and then you look at the master plan and see the extent that they're consistent or they leave and approaches meaning nothing, that if that happens, to the extent that that happens, you should include in your papers how that jives with the purposes of this sign regulation that we're talking about.
Which, by the way, was enacted at the same time as the master plan that used the word approaches. So they were talking to each other, so what's up with that, right?
So if you're saying that it's meaningless in certain contexts, say how that's okay.
Yeah.
Give us some legal framework for understanding meaningless portions of statutes, basically.
Okay, I just want to respond to Commissioner Romata. I think it's an assumption that they were talking to each other.
It's all from city planning.
I understand, but when I read the city planning reports, there were distinctions made within the reports between master plan and zoning. They're two different animals. The master plan was concerned with roadways, zoning, where 21B came in, and that was enacted in 1940 with respect to, restricting advertising signs. That's zoning, and they're clearly identified that way in the CPC reports.
Yeah, that's correct, but it's true that I'm sort of sending myself in the time machine back in time, imagining what city planning looked like in 1940, and I'm taking a wild guess that it didn't look that different than it does today, in the sense that there were commissioners who were aware of all of the actions that came before the agency because they had to vote, right? Not to mention Robert Moses. He was a busy guy paying attention to a lot of things, right? So I'm thinking that they were very aware, especially because they voted within either days of each other or weeks. I can't remember if they're both in April, but they were aware.
But for that very reason, they distinguished between the master plan and zoning, and they took from the master plan so that people would know, property owners would know, that if they are within 200 feet of an arterial highway, they would have a problem putting up an advertising sign.
Arterial highway and approaches. The arterial highway thing and its approaches.
Arterial highway. 4253 is a two-element definition.
Right.
Two elements. It's and, not or.
Right.
When the word and is there, and I apologize if I'm being professorial here, but when the word and is there, both elements must be satisfied.
Right.
So when we look at the first element and we pull out our master plan and we examine it with a magnifying glass and we do not see an arterial highway, we close our briefcase and go home, because one of the elements have not been satisfied as a matter of law.
Okay. We'll have to go
I just
into this
wanna-
more. I think we
yeah,
can talk.
just
We've talked
before
about
I-
this before.
If I may, I just would like to just close up with one
Thank you.
final
Thank you.
point. And you actually, Madam Chair, gave me a great opening, because you just pointed out that it's safe to presume that when city planning does something, there's thought involved, and that it's deliberate. So that takes me to this little...
One would hope.
Right. Well, but this takes me to this. This is the, this is what, I think we had, one of the blow-ups I think you had requested was, we're showing the master plan blow up a
Blow-up of the master
blow-up of portions of the master plan from 1945 and 1963. So 1945, this is the Lincoln Tunnel. I'm sorry, this is the Lincoln Tunnel and this is the Holland Tunnel. And, both tunnels were represented as just a series of dots leading to the beginning of the street system in Manhattan. In 1958, before I get into 1963, in 1958, and this is reflected on the 63 map, and this goes back to the case that the board decided last year concerning the Lincoln Tunnel Expressway. It amended the master plan to add the Lincoln Tunnel Expressway as part of the Lincoln Tunnel crossing and therefore an arterial highway. On the same day, in 1958, January, I think 11th, 1958, when the City Planning Commission voted to make that amendment to the master plan, it approved a plan by the Port Authority to create the Holland Tunnel exit rotary between Late Street, Erickson Place, Hudson, and Varick Street. Yet, they did not amend the master plan, and that is shown here. The master plan in 1963 for the Holland Tunnel looks the same as it did in 1945, and it specifically chose not to amend the master plan to add the exit rotary. And that, again, I think goes, I mean, there's so many points that overlap here, but that goes back to the point that you so clearly made and that we have been making as well, and that is that, you know, it's so important that the zoning resolution give clear notice to property owners as to what they can and cannot do. And, you know, if the exit plaza or the entrance plaza, which contains roadways, becomes part of the arterial highway to which 4255 applies, it's just a moving target. It becomes impossible. And, you know, the city planning had the opportunity to make the amendment, it chose not to.
Thank you.
Okay, thank you.
Thank you. Anybody else? Any other questions? Commissioner Montanez?
No.
It's okay.
I'm sure it'll be
Sorry.
addressed in their response.
Okay, DOB, please. Thank you very much.
You can't see it, but
You see it?
you need the lights. Oh, there,
it's
it's
coming up
getting,
better.
yeah, it's coming
I
up.
think that's,
Give it a minute. Better?
It's good.
You see, oh, yeah, you good with that? Okay.
Good morning, Kurt Steinhaus for the New York City Department of Buildings in 121 Varick Street, BSA calendar number 27813A. This PowerPoint is ready because we considered a lot of the board's concerns during the review session with examining the appellant's research, and we felt comfortable that the legislative history just wasn't persuasive in this case. All right. We deal here with the law of billboards, and as the court has held, signs pose distinctive problems that are subject to municipalities' police powers. This is so because signs take up space and may obstruct views, distract motorists, displace alternative uses for land, and pose other problems that legitimately call for regulation. This outstanding display is one of the last advertisements seen by the tens of thousands of motorists that enter the Holland Tunnel each day. This huge display is located just above the entrance to the Holland Tunnel, and at 5,625 square feet, it is the largest sign not just in the Holland Tunnel area, but downtown Manhattan as well. This sign demands attention as commuters traveling out of NYC are forced to view it while moving at extremely slow speeds. And we see from Google Street View that this advertisement is the sign at 121 Varick Street.
Sorry, did you say extremely slow speeds?
That's what the copy said, yes.
Oh, okay, that's what the copy said.
Sorry, I was quoting directly from the advertisement.
Oh, okay. So for the advertiser is saying people will have time to read the sign because they're traveling so slowly.
Right, so this is basically the harm that sign regulations are meant to prevent in terms of aesthetics and traffic distractions. So today we're going to be discussing why the sign at 121 Barrack Street is within 200 feet and within view of an arterial highway. We're going to go over a visual history of the plaza, discuss the zoning resolution, the master plan and city map, address notice concerns that the board had, and the implications of a potential mistake in the appendix of the zoning resolution. The sign at 121 Barrack Street is within 200 feet and within view of an arterial highway if we're just looking at the entrance to the tunnel above Broome Street. Here we see the Holland Tunnel Plaza in 1996. The source for this was the New York City's official online map that DeWitt prepares. It's an aerial view. As you'll see, there are the overhanging entrance signs.
Kurt, take the mic with you as you go.
Sorry. As you see, there are the overhanging entrance signs at the entrances, and traffic is blocked off along Broome Street.
How do we know that this is from 1998?
1996.
Oh, 1996. How do we know this is from 96?
We have a link on one of the other slides. It's actually available online at the New York City map with 1C. And so it has different aerial views that you can select, and this one is from 1996. I believe that 2012. There's also 1951 and 1924 other aerials that we'll be showing you.
Okay, but how are these date stamped? Like, how do you know that that's when that was photographed?
It's
Like what, you know,
right.
who's the authority for when that photograph was taken?
The drop-down
Are these city
menu
records,
provided.
Council?
There's
These are
it's-
official records of the city, right?
Right, it's on our website. That this it's not
The website's not official.
right. It says on the map, copyright the City of New York, if that is any.
Copyright City of New York, 1996?
No, 2015.
Oh, so we don't,
Right.
any more information about how you know that this is taken in 1996? Because
Okay.
unfortunately, you know, Google is
Mistakes.
flying around and stuff
Right.
like that. How do we know when this is, right?
Okay. So here's the sign at 121 Barrack Street that they erected pursuant to a 1998 permit. It was within 200 feet and within view of an arterial highway, specifically that point right there. So.
Wait, sorry.
Oh,
Go back.
sorry, yes.
Sorry. What are you saying is the what's that
We're,
point?
we're saying that this part is, for the purposes of this discussion,
Yes.
this is the arterial.
Oh, you're not
We're just
talking
looking
about
at
Broome
this.
Street now. You're
We're just
only-
looking at this.
Oh, okay.
Once you cross the street line and you're above Broome Street on the tax lot that the Port Authority owns.
Okay, so at that yellow dot, you're
This
saying
yellow
the
dot.
sign was visible?
Yes,
Okay. Based on,
based on Google Street View. So this is where the sign would be. We're going to show you pictometry pictures that are aerial photographs of the sign. They extend over the top layer of windows. And what other features? As you can see down here, the little man is sort of standing there above the street.
well, where, yeah, is he at?
He's above Broome Street. We'll be submitting more detailed pictures about the actual
Well, so this
location.
is done from Google. That's why I wanted the property owner to actually, I mean, because I understand DOB is not going to send people out on the street and like risk their lives.
We don't have
But
access, I asked.
maybe the property owner can actually walk there and take a photograph. I don't think they're listening though, so we'll get back to that. Okay.
The police won't let you down there.
Because, sorry?
The police won't let you down there, I asked.
You what?
I've walked down there.
Yeah. So Commissioner
They
Montanez
look
like
at you a
risks
little
her life.
strange, like, what are you doing
Don't
here?
ask
But there's a whole bunch
permission.
of police cars right at that
They
barricade.
have-
Okay, so it's,
You can't get that
It's
much
literally in the
further.
middle
Just
of the
the
street.
sidewalk.
But just
You
at the
can get to the
barricade.
police barricade,
Right.
yes, but you can't go into
so how
the-
far are you
the
in
ramp.
there? Are you
You're
past
about,
the police
right, you're about
barricade?
30, you're about 28, let's go to within 200 feet. Okay, so this is pictometry. We did a lot of calculations. So the sign at let's go to Pictometry Notes. Okay. The sign locations, it's about 5 feet from the facade, which we use pictometry to measure. Here's the sign. You see it's covering the top layer of windows. The sign width is 75 feet. The radius that we're looking at is 200 feet. That's from the zoning resolution. The viewpoint, using the sort of swivel turnaround in Google Street View, we looked at the windows on this building right here, 250 Hudson Street, and we noticed that there's a doorway. And so in pictometry, we used a different view to measure along Broome Street, and we see that it's about 28 feet north. The point that we're viewing from Google Street View is about 28 feet north from the street line at Hudson Street. And using the middle of the lane, calculating on the picture, not the building outlines, we see that from using the picture from the bottom corner, the southeastern corner of 250 Hudson Street, along the street line to the middle of a car going through, that this is about 31 feet. And so that points you right here.
From that building?
From that
wall of the building, about 30?
From the wall of the building along the street, line, it's to the middle of this lane, it's 31 feet from Broome Street. And so that forms a square that takes you up here. So that's the approximate location of Street View, which is available to everyone online. And the sign isn't posted because the Street View is from, I want to say 2012. But at this location, and you can, this is the one point. I know it's a little bit, it's independently verifiable, but there are multiple points in this area, and there's one point where you can see 3 stories of the building, and this is where the sign would be. So that's 3 stories at the hypotenuse of the triangle is, I mean, we're looking at part of it, we're looking at 360 standard. I've checked this multiple times. I'm happy to provide instructions so that other people can look at it, and like I said, I was just down there the other morning. I took the picture for the opening slide, and even with a DOB ID, the police don't let you down there.
DOB, yeah. Okay.
Yeah,
That's
right. It's a safety concern to be standing in the middle of the street, and also you don't have access. There's a walkway that goes.
What about at 4 a.m.?
If the owner of the sign wants to go down there at 4 a.m., that's something that they can work on.
Wow, that's impressive.
So
I don't know how to do the pictorialization. Do we have skills like that?
We have to get a subscription to Pictometry Notes.
Oh, is that what it is?
Planning has one.
Okay.
So we can provide instructions for the exact analysis and the steps that we took so that you can independently verify what, and sorry, the most important part. So the distance at the viewpoint is 180 feet. And keep in mind when you're measuring the distance from the sign, it was a little bit over 5 feet, but I mean, to be
over 5 feet.
it was like about 6 feet, let's say.
5 feet, 206 feet away to the corner, is that what you mean?
The corner from the sign right here to the facade along Varick Street, it was over 5 feet, so it was between 5 and 6 feet. But that doesn't really matter for the 180.
Encompasses most of the sign.
Right. So this is all of the analysis that I was doing was sort of in the applicant's favor in terms of the assumptions we were making.
Okay.
Okay.
Impressive work.
Thank you. So now we're going to look at a visual history of the plaza using aerial photographs. So this was from the city map aerial view in 1924. As we see, the Holland Tunnel isn't there yet. Here we have opening day 1927. As you can see, the traffic patterns existed. Existed on opening day. You can see the toll booths. You can see these curbs that are blocking access from Broome Street to the plaza. right here are the traffic patterns in 1929. You can see the traffic lines on the access lane from Broome and Barrack, and also the curbs blocking access along the plaza boundaries. And so that's basically what an approach would be. It's the point of no return.
That's a Rule 49 analysis, right? As opposed to the other analyses we're talking about. I mean, frankly,
Right.
you showed those photographs, and so unless the owner can take a real-life picture from essentially the same spot and show us it's not visible, that's pretty convincing. But what you're talking about now is that under Rule 49, point of no return, this looks like the point of no return,
Right,
even in 1929.
Right, the interpretation. The department, the Rule 49, the department's official interpretation of the appendix.
But it's not, for the benefit of what we've been talking about, it
Yes.
doesn't go to the definition of approach that's indicated in the zoning resolution, and the fact that this stuff isn't shown on the master plan or on the city map and isn't defined, et cetera, that's not what you're discussing here, right?
Right
Or
now,
you will
we're
later.
discussing characteristics of arterial highways. So this was from the City Planning Commission report in 1940. It stated that an express highway, a type of arterial, is a facility suitable as part of a metropolitan or federal road system, providing for substantially uninterrupted traffic flow by eliminating intersections at grade and traffic lights, with on and off access at infrequent intervals, and with no rights of direct access from abutting properties. So this is from the City Planning Commission report in 1940. So this was just sort of to provides further support that the department's interpretation of Rule 49 is appropriate, and it has basis because it's describing characteristics of an arterial highway.
So what you're saying
yes.
is that plaza, for example, which we know it as an entrance plaza, is that on and off access at an infrequent interval?
Yes. In terms of, we would, my interpretation was that these would be infrequent intervals, and once you're in the plaza, you can't leave. And so it had, the City Planning Commission was talking about the functional characteristics of arterial highways when it's expressing, talking about express highways, and that the plaza in 1940 and 1929 in its original incarnation has those characteristics.
So it also says with no rights of direct access from abutting property. But in fact, you do have, do they mean vehicular access, or do they mean any kind of access? Because unlike some approaches, some obvious approaches, there are walls, right? Like just at that point where you were standing to take your pictorial photographs, there are walls there. So it's so bad that you can't even go there with your DOB badge, right? But there is actually access to those vehicular crossings simply by pedestrians. I mean, you can actually, you did it yourself. You can walk there, right? So that's different than where, so I'm not sure what they meant by no right of direct access unless it said no right of direct vehicular access from abutting property.
Okay. This is an excerpt from the book Hudson River from New York City to Albany by Erin Richmond, and it notes the approach and entrance to the Holland Tunnel in New York City. So that's just sort of, I guess, supporting evidence that this was considered an approach in its time.
At least by that author, who's not the Port Authority. Planning, right.
Okay, so this is the aerial view in 1951.
What are we looking at?
There's probably a UFO in there, but these are the, basically, this is to show you that.
That's Lindbergh's. I found that article
right there.
about Lindbergh. What was that, 1920 something?
So the curbs are, basically the plaza looks like it did before in 1951.
Oh, could you go back?
Those are
It took us a long time to figure out even what we're looking at, okay.
Yeah.
So those white things are toll booths? What are we, the thing that forms that sort of little chain, little necklace, is that?
Yeah.
Are those are the toll booths? I guess there were a lot of toll booths.
They were there until
in 1951. They were there until the 70s. Yeah.
Right.
But couldn't you argue, for example, that that the entrance only starts at the necklace, the approach, because that's where the toll is. That's when you actually go through the toll crossing.
That would be arguable. I believe our position in terms of that is that can you really turn around in terms of when you're with Rule 49, can you actually turn around in this area? That would be an important question that we would look at.
With Rule 49.
Right, with Rule 49.
Okay.
And so Rule 49 was supposed to address situations and give notice where you've reached the point of no return so that people would know when they're applying for permits how the department is going to issue them. So the National Historic Landmark nomination says, despite modifications to the toll plazas, new toll booths, and lane patterns, the general traffic patterns as established by the separation of the exit and entrance portals remains largely as designed. The original toll plazas, the photograph wasn't in the report, were redesigned in 1954. So this was 1951, and so now we're at 1954. And until 1971, tolls were collected in both directions. At that point, the New York toll collection booths were removed. Here we have photos from the EPA of the Lower Manhattan entrance to the Holland Tunnel. These were taken in 1973. As you'll note, the traffic patterns are the same. The entrance or the access from Hudson Street and Broome Street has been removed, but
Sorry, I'm not
looks.
understanding.
Sorry.
What am I looking- This looks different than the other one. Where are we? North?
Sorry, this is the entrance to the tunnel. It's not an aerial photograph. But so this is Canal Street down here.
Right.
Hudson Street and Broome Street. So the plaza is.
It's on the other side, right? But you don't see what.
So you don't see the critical right-hand portion from this angle.
Okay.
But sorry.
You might argue. Go back.
Yeah.
To that one. You might argue that, because maybe the sign's visible from back, you might argue that this part's an approach, however you argue that.
Right.
And so standing further back, you can certainly see the sign, I think. I don't know. Well, let's say you can see the sign. But,
Right.
so, and those things, those are just white lines, or those are?
It appears that they painted.
Just painted.
Right.
Yeah. Okay.
Along the street.
So again, if we just talked about what you read before about not allowing access on, that's again, access by what?
Right.
Could I, maybe I'd be breaking the law, but could I, if there are cars parked there, could I join on when there's not a lot of traffic and just get onto that tunnel?
I don't usually drive across traffic lines.
There's cars that are parked in that plaza. What'd you say?
I don't usually drive across traffic lines, but.
No, I'm not saying you should break the law, but there is access.
Right.
Physical access by
Physical
humans,
access.
so.
Okay, so this is another view of the plaza in 1973. So this actually shows what the department has coined the Broome approach, but we can call that the Broome access drive from this direction. And this is the Watts access drive and the other access drive right here. And Broome Street, this is Dominic. And they're entering the tunnel. So this sort of gives you another overview of what the plaza looked like in 1973. So the National Historic Landmark nomination indicates that the toll plazas were redesigned again in 1988. So the next information we have, and this is again from the city map, and so far the online information that the Department of Information Technology and Telecommunications has provided to the public on the city's official website, which indicates that the source of this aerial photograph is 1996. And so this is presumably the latest incarnation of the plaza redesign, where they've basically just done some streetscaping and beautification modifications to the plaza. As you, again, the overhang entrance signs are there. They might have been added during the second redesign. I'll note that the EPA from here, this is the area where the overhanging signs would have been. It doesn't appear that they're there in
So arguably,
1973.
there's no notice at that time that you were actually, that's
Right.
where, not that I really drive, but that's where there's the part where you get on it and all of a sudden, oh my God, I'm going to New Jersey.
Right.
How do I get out of here?
Right. So this is the point where you realize you're in New Jersey.
Counselor, is Broome Street closed off in that image? It doesn't.
So Broome Street, no, it's not. And I'm not exactly sure what to make of that in terms of the traffic patterns. I think that it's entirely possible, based on some other maps that we've seen, that this was actually a different approach at that point during, under the Rule 49 definition. Broome might have had access, or this line might have come. I'm not exactly sure what's going on with that access point right there.
But in 1996, it's closed off? In the next slide?
Right, in the next slide, it's, the paint is fresh. You can see that Broome Street, you can't
There's a
enter
line,
there.
there's an actual line there. Oddly, you can't.
So in 1973, the traffic pattern might have allowed you to enter the tunnel. I can't say exactly. So let's talk about the zoning resolution and why we're actually here today. Zoning Resolution 4258 was from 2001. It says that a sign erected prior to December 13th, 2000 shall have non-conforming use status, where such sign shall have been issued a permit by the Department of Buildings on or before such date. Nothing herein shall be construed to confer a non-conforming use status upon any advertising sign located within 200 feet of an arterial highway and within view of such arterial highway. So this is addressing signs. All right, in 1998, the zoning resolution said, 42353 said, no advertising sign shall be located, nor shall an existing advertising sign be structurally altered, relocated, or reconstructed within 200 feet of an arterial highway if such advertising sign is within view of such arterial highway. All right, Appendix H, which was C then, notes under toll crossings, Holland Tunnel, and approaches. And to address concerns that we mentioned in terms of the point of the zoning resolution, we would note that a tunnel is distinct from a bridge. And so the most important part for sign regulations is actually this word right here, because at a tunnel, you're underground. When you're regulating signs and prohibiting them, you can't see the sign from underground. And so the purpose of this statute is to prohibit the view. That's the harm that we're preventing here. The view of the signs from the approach from arterial highways. And for tunnels, those are distinct from bridges, which the appellants mentioned the Triborough case. And if you read that closely, it's actually talking about the distinction between the Brooklyn Battery Bridge project, and it really focuses on the word bridge. And it says that that can't be read to mean the Brooklyn Battery Tunnel, because the harm that's being prevented is the view, and when you're underground in the tunnel, you can't see the signs. But here, we specifically see that approaches is the relevant part for preventing the harm that this is addressing. So this is actually the most important word in the appendix. And so if we were to say that it's just the tunnel, that would completely gut the regulation, because you would be standing inside the portal, the entrance to the tunnel, and what can you really see from there?
But what if it was only that section that's known as the open cut portion of the tunnel where your Google guy was standing? What if that was the only approach?
In this case, I believe it would be...
What if that was the actual definition of approach?
So I would like to discuss what the regulation actually says for arterial highways. It notes that arterial highways shall include all highways which are shown on the master plan. And so the analysis that we've been doing is very interesting and intellectually stimulating, but the zoning resolution in 1201I says mandates, this is a mandatory requirement. The word includes, shall not limit a term to the specified examples, which in this case would be highways shown on the master plan of arterial highways, but is intended to extend its meaning to all other instances or circumstances of like kind or character. So this is actually how we're interpreting the regulation in 1998 to determine whether the permit was lawfully issued.
What's the like kind that you're referring to there? What's the
The
like kind or
like kind or
character?
character of an arterial highway.
So what's the like kind or character of an arterial highway? What the approaches are of like kind or character?
Right,
Sorry,
so,
I'm not making the connection.
sorry, the connection would be when we're looking at the toll crossings, we're looking at everything on this list, we're looking at the characteristics of the approaches, if that's just the entrance to the mouth of the tunnel, and those roadways were then paved, if that, the extension from the, we'll go back to amount.
The cut?
Okay. So if the original, so if this in 1961 was the only approach, and then later these were paved and added in, if that's a like kind or character, a similar circumstance, if you're the same here as you used to be here, which...
Same in what way?
The same, our interpretation goes, our official interpretation goes back to Rule 49, that the character of an arterial highway is, and the approach to an arterial highway is that you can't turn around.
But so you're always applying Rule 49 as opposed to what you pulled out of the city planning report, which was simply access, right? As
Right.
opposed to no point of return by a car, which is the way Rule 49 works, right?
Right.
No rights of direct access from abutting property, which is a different standard than no point of return, vehicular
Yes.
return, right? Okay.
Okay, so that takes us up to the Holland Tunnel Plaza. So even if we're, this is what we just stance. It was a point of no return in 1998, and today, this is the department's official interpretation. As we said before, we haven't recognized any other. The city's really stepped up its enforcement efforts, and basically since 1998, and we've won a series of high-level cases, Clear Channel, Infinity, at the Second Circuit and the other federal courts, that basically upholding the enforcement scheme.
It's upholding the enforcement scheme, but is
Right.
it upholding the department's application of the word approach and with specific
That
with
issue
respect to
was
where it's
not-
located in the Holland Tunnel and so on?
That issue wasn't
Right, so
addressed.
that's the issue. Okay, so we know that the court has favored Rule 49 and,
Right.
And the registration of signs and all of that stuff. Okay.
Okay, so this is, we're going to discuss the city map and master plan. As you mentioned, the water crossings provided as toll facilities by specially constituted authorities, which together with their approaches are essential links in the arterial highway system and major street system. And they're listed below, the Holland Tunnel is listed. And this is just sort of comparing the characteristics from the 1940 designation report, which you pointed out correctly, says on and off access at infrequent intervals. So 1940, it also mentions that an established facility like the Holland Tunnel is defined by the Commission as one which does not require any further map change in order to make it satisfactory. It may not actually have been built to its mapped lines and treatments, but the necessary right-of-way. Here again, we have sort of right-of-way. If the right-of-way extended from Broome Street down through the plaza when they're painting on those lines, that might be a consideration. Has been officially mapped, and no further action by the City Planning Commission is needed insofar as its status on the city map is concerned.
So the fact, though, that the Appendix H, formerly C, requires as part of the criteria, or assumes that part of the criteria is that the below thing has been shown on the city map, and you cannot, for the life of you, find it anywhere on the city map, that's okay? How do you reconcile that? In terms of, again, giving notice to property owners, how do you reconcile when, for example, an architect or an engineer has to tell their client, great location for a sign.
Right.
I'm going to check what it says in the zoning resolution, master plan, city map, we're good. What do you do? What do you do about that?
So I would say that, sorry, which version of the plaza are we discussing right now?
No, it's actually not the version of the plaza.
Oh,
It's the
okay.
city map. Because if you're an architect or an engineer and your client is asking you, I have this great building at this location, I think it's perfect for a sign, it has this blank brick wall, you can see it when you're driving up 6th Avenue or wherever you're driving. Because this one, I think this is actually, the sign is kind of odd because it's very visible to pedestrians walking up Varick, but less visible to drivers because you have to get so far back in order to really see it. So it seems like pedestrians are the ones who benefit most from this sign. But with respect to the text and what an architect or an engineer has to do in order to advise their client about whether they should apply for a sign permit, right? And by the way, it's an architect or engineer, their sign and seal, kind of is their livelihood, better not mess up, right? So they are sealing, and the buildings department asks them on a little form, is it within 200 feet of an arterial? And their answer is, based on what it says to do in the zoning resolution, look on the master plan, look on the city map. Given how impossible it is to get a copy of the master plan, I'd say that most people are looking at the city map, and the second that you look at the city map, you say, not only is the entrance plaza or an approach or whatever that thing not shown whatsoever anywhere, I can't even find the Holland Tunnel on the map.
Right.
Right? You can find it on a Sanborn map, interestingly, but that's not the city map.
Right.
Google
So
also has it.
my response to an architect or engineer is that it says Holland Tunnel, and the fact that that isn't shown on the city map, you're going to need to use secondary sources to find out where the Holland Tunnel itself.
What are your secondary sources? We can't even find them.
So one secondary source that they might use is a Sanborn map. They could do a site visit. Again, this was in 1998. I don't know if you've been listening to Serial, but things were very hard to prove back then in terms of documentation. But that isn't as much of a concern going forward.
But isn't that like a statutory, failing? Because it's not, you're directed to do for instance, when you're working on zoning regulations that have to do with height and setback, right? It tells you, are you on a wide street or on a narrow street? So you go to the sources that tell you wide street, narrow street. Officially, that's the city map, right? And it tells you whether it's 75 feet or whatever. Most of us actually look at a Sanborn map because it's easier to get, but the official statement is the city map, right? What if no street widths were shown on the city map? Where would we all be, relying on Sanborn to regulate zoning?
I don't have an answer to that question, but a sort of follow-up question that I had was whether other approaches are shown on the official city map, whether the Lincoln Tunnel has its approaches shown on the city map, or the George Washington Bridge. Is this sort of a systemic problem that existed in 1998 that people sort of had a way to address secondarily, or is it specific to the Holland Tunnel that the city map shows it as a tax block and tax lot? But also, in terms of notice in 1998, if you were to do a site visit and you're looking at the city map and it's not showing these roadways, they're not mapped streets, and it's not showing the entrance to the Holland Tunnel, that's not a mapped street either, then what is it? If you're looking at the appendix to the zoning resolution and it says Holland Tunnel and approaches, and you go there and your experience is maybe you're confused about where you are, and the plaza's roadways, you think that they're part of the street network, but you're standing there with the city map and it's not on the map. Doesn't that give you sufficient notice that is an issue that needs to be examined very closely. When you're standing in the plaza, when you're standing in the middle of that street, that because it's not on the city map, isn't that notice in and of itself, wouldn't it be more problematic to have the access drives in the plaza on the city map and have people confused that that was part of the local street network as opposed to part of the arterial highway? Wouldn't that be, when you go over, if it were mislabeled on the city map, and it didn't distinguish between the access drives and the local street network, wouldn't that be more confusing when you did a site visit? Doesn't it sort of put you on notice when you're standing there and the plaza is just one big block and you see the roadways on the street that something else is going on?
It puts you on notice that there's a huge inconsistency from what you're seeing. You're seeing like lots of traffic and all this stuff and signs. According to your photographs, that sign was up there in '98. So it's true that you're saying, whoa, what's going on? Because the city map isn't showing anything. And I'd have to say that an architect or an engineer who was relying on their stamp and still working as an architect or an engineer would have, with careful diligence, gone to the Department of Buildings and said, I'm not sure what I'm supposed to do here. But unfortunately, we don't know whether that actually occurred. It would have been a lot easier if there was something like a recon or a pre-con in the file. Maybe there is, I don't know, that indicated that they actually did ask DOB, which I do here, and DOB at that time didn't have the interpretation that it claims it has
today.
Claims it had, right, and does have today. Right. So.
Right. It was a Directive 14 application. If that.
So it was a self-cert? No, it was Directive 14. That's different. That's just an inspection, right? So it was not a self-certified application, right?
Those are
Yes.
examined for zoning compliance.
Yeah.
They are not inspected by the Department of Buildings at the end.
Directive 14 is not inspected by an examiner?
That's correct. The registered design professional does the final inspection.
Does the final inspection,
But the zoning review
the
is done.
zoning review is
Correct.
done. It's not a self-cert.
A cursory review.
Yeah, whatever.
But
Some
it is
kind
checked.
of a review
It is a
done.
check. And
Yes.
zoning egress and fire safety, I believe, is the standard.
Sorry. So. Okay, so this is, as we've seen, the master plan. Here's also a comparison of the zoning map in 1961. And as you can see, it shows the unbuilt Lower Manhattan Expressway. It also shows, we'll do a zoom in. It also shows the access drives in the plaza. So in 1961, maybe you would turn to the zoning map to find out what's going on.
So you're saying an architect would be on notice because they see all that stuff on the zoning map, even though it's not on the city map?
Right. And so this is the traffic pattern from the Lower Manhattan Expressway. You would sort of go up, come down and around, and use the access drive through the plaza to enter the tunnel. All right.
You loop around?
All right, and this is traffic accessing the Holland Tunnel from Canal Street. Accessing it again from...
Excuse me.
Yes.
Sorry. This is from the zoning map, a historical zoning map?
The historical zoning map in 1961.
Was the Lower Manhattan Expressway, was that a mapped but unbuilt expressway at the time?
Yeah, you see on the right?
It's right, sorry,
because
yes.
it's showing up on the zoning map, which it sort of indicates to me that it is a mapped but unbuilt expressway, because it no longer shows up on the zoning map. Is that correct? So I think it would actually be useful to see if there was a mapping action to demap the Lower Manhattan Expressway, if it was indeed mapped, and how that mapping action dealt with these connections and approaches, because it may be that they were demapped, but then they may have existed in mapping land at the time of the site.
So this is...
So you got that? So That's, I'm not sure who's going to actually do this, but.
I mean, okay, so I can give you some guidance. The historical maps you can find at the Borough President's Office. The actual mapping applications, in terms of the sketch maps that show what was being eliminated and what was being added to the map, those can be gotten from TRD, Irene Sadko, and
Technical review.
yeah, technical
division.
review at City Planning can get those.
Okay.
Okay, great.
So this is the zoning map that existed in 1995. It labels the Holland Tunnel Plaza. So that doesn't really address the issue of whether the plaza was an approach in.
And now you don't even find it again.
Right.
You find the Holland Tunnel.
Well, it disappears around there, but.
No, but there's no way into the Holland Tunnel. It's unbelievable. You can't even find that there is one.
It's a simplification.
What are they thinking?
So as far as notice.
Simplification. Okay.
I'm not sure what happened. The Holland Tunnel Plaza in 1996. This is the DOF digital tax map that we'd previously provided. If you zoom in enough, it does label the plaza, and the reason we didn't submit this is it seemed kind of conclusory. It labels the Holland Tunnel approaches a
Right.
PPR.
Oh, when this digital tax map, normally the tax map is supposed to be determining what the block and lots are from deeds. So according to that information and how they make those tax maps, there should be something somewhere in the record which you cannot find. There's zero information in the kind of digital world anyway about who owns that or what that is. It's like I went on Property Shark and they told me it's public, it's owned by the Port Authority.
Who owns this?
Yeah, but when you go on just to look at the tax map, you don't find deeds to support what that is. And you would think that the deeds then would be giving that information, because how does the tax department know whether it's an approach or not an approach? You know, the guys who are actually drawing the maps.
Was the state of New York and the practice of having deeds to state-owned property in 1920? Is that might be why there isn't a deed for the property?
But where do they get the information? That's what's so confusing about that. Is that sort of the free will of the tax map drafter? Or was there some deed information that indicated where those lines should be? I've never seen that done before, where you don't see on the deed the meets and bounds of a thing, you know? And I think that's so strange. So I don't understand what we're getting that information from.
Right. It also appears on the DOF city map. The reason that I had expressed that the 1973 EPA photos might indicate that Broome Street is an approach is that the DOF city map, the DOF online map, is labeling it an approach, which is not our experience that we have today. You've seen that. These are the plans in the permit application. As you'll note, there's a pretty big discrepancy in the size of the sign. We know that it's 75 feet. We know that this wall is 91 feet. We know that the Holland Tunnel is over there. We know that they haven't labeled the Holland Tunnel. We know that actually it takes up about that much space on the wall. So this is sort of the paper trail that part of the paper trail
The
that
sign's not drawn to scale, in other words.
right, and it didn't list any distance to the nearest arterial highway.
But does it describe the size of the sign on the permit application?
Yes,
Okay.
and other, yeah.
But it doesn't.
I don't know if that's
doesn't
standard
locate the
practice.
tunnel anywhere in any of the permit application documents.
I did not see that. I can submit the documents that we have from their file.
And this goes to whether or not the applicant at the time made it clear to DOB that the Holland Tunnel was somewhere in that general neighborhood.
Right.
Or Broome Street or anything. So there's no site plan beyond this?
I believe that this is the only site plan that we have. I'll submit all of the documents we have in case I'm misinterpreting. And we do also have, and I'm not sure who prepared this, but it's a graph paper schematic that does locate the sign. I'm not sure if that was prepared in 1997. I'll check what our sign department has to say about the documents. Okay, so if we're assuming that the plaza was an approach and that it was sort of properly mapped, the City Planning Commission wouldn't have had to make any changes insofar as its actions with the city map and the master plan. So they didn't amend the city map to remove the arterial highway, but did we? I don't think we discussed the part about how the city map actually reflects that it's not reflect. My interpretation is that the city map, or our interpretation, sorry, is that the city map doesn't reflect the Holland Tunnel ending at Miller Highway, which is nobody's real life experience. It actually reflects an overlapping of the Holland Tunnel and the Lower Manhattan Expressway. And there was support for that.
That never got built.
Right, that never got built. As you look at the zoning map, the Lower Manhattan Expressway is branching out all over the place versus the Holland Tunnel comes down here. There's this little plaza. And so our interpretation of the city map is that it's actually reflecting an overlapping, and it was a mapping design decision.
An overlapping?
An overlapping of the Lower Manhattan Tunnel and the Lower Manhattan Expressway and the Holland Tunnel. And so this reflection, it doesn't end at the Miller Highway. This, they chose to show the Manhattan Crosstown Expressway.
But as you could imagine, if there really was a Lower Manhattan Crosstown Expressway built, and you can actually go online and see photographs, of models, for how that was going to connect. It would have to, people would come up from the tunnel, get off, however they get off to come into the local street system, and then go up a ramp to get onto the Lower Manhattan Expressway, right? So that's probably what all that stuff is. So you can't really go by what that is, because there was an intention to build ramps, true clear approaches to both the expressway and the tunnels, or egress from the tunnel and approach to the expressway. So I don't think you can rely on stuff that has to do with never built, scary roadways like that.
Okay. Okay. No further action. So what if it was a mistake? Where does that sort of leave us here today? Assuming, and these are from the appellant's arguments, that the City Planning Commission never intended to designate the plaza as part of an arterial highway in 1940. What's the relevance of that to the permit in 1998? Issues are whether the plaza was part of an arterial highway in 1998, whether the plaza is part of an arterial highway today. Yes, and we look at Rule 49, so that's not...
That's if you apply Rule 49.
Right, if we apply
So if it was
today,
a mistake, then you'd have to argue that Rule 49 applies in 1998 when Rule 49 is from 2005.
Right. Well, no, I would say that because the zoning resolution is addressing the concern of arterial highway sign regulations, and it specifically uses the word includes, that like circumstances of like character would include the plaza as it was in 1998, because when you cross that sign, you think to yourself, I'm in New Jersey. You think to yourself, I can't go back. I'm on the approach to the tunnel, which is the most important part of the sign regulation for the regulations for signs when it comes to tunnels. So it's not necessarily the Rule 49 definition. It's definitely, it agrees with the Rule 49 definition, but because the text of the zoning resolution in 1998 used the word includes, it didn't say that these were mandatory requirements for the city plan, the city map, or the arterial highways. And 1201I specifically says similar circumstances or character. When you're in the plaza, it doesn't seem to be a different circumstance than when you're in the mouth or the
open cut.
Right, the entrance passageway. It doesn't, for the purposes of sign regulations, it doesn't, in 1998, you're the same here as you are here, which is why the zoning resolution used the word includes. It didn't want us to have this sort of, well, if it's not listed on the city map, then, well, that's a requirement. It specifically it says shall include the arterial highways on the city map and the master plan. But the fact that it uses the word includes is why we would interpret the zoning resolution in 1998 as including the Holland Tunnel Plaza.
They're of similar...
Because they're of similar character, similar circumstance, the same harm that's being prevented by the sign regulations in 1998 without looking at Rule 49.
Any other questions?
Oh, sorry, can
you have more to-
sorry, there was a little bit more about the enabling legislation. So this was actually a compact between the states of New York and New Jersey. As you noted, the construction had already been built. The issue is more whether the plaza at that time was considered an approach. In order for the Port Authority to do construction, it needs to have authorization from both states because it's a bi-state agency. If the Port Authority, I don't think that anyone's arguing, hopefully, that the Port Authority does not have the authority to construct approaches to the Holland Tunnel. But if we assume that the approaches already existed, which is our argument, then there would be no reason to include that in the enabling legislation.
Well, what do you do about the fact that there's a difference in terminology between an exit plaza and an approach in the Port Authority regulations?
My response to that would be that those are traffic regulations. We're looking at, here we're looking at, another key distinction there is that the enabling legislation was drafted as an agreement between the states of New York and New Jersey. The traffic regulations were actually, those were prepared, written, drafted, authorized by the Port Authority itself. And so it would be a similar circumstance to the IRS coming to you and asking, how do you think that we're going to tax you? If you're looking at the Port Authority's own drafting regulations to determine how signs in the zoning resolution are going to apply, then it sort of seems like a conflict of interest there if we're looking, because the signs are on city property, and so why the Port Authority's traffic regulations are relevant doesn't...
No, the signs are on Port Authority property, actually.
No, I'm sorry, they're on private property in the city of New York.
Is it on private? You see
Yes.
those...
Which sign?
You're talking about-
I'm sorry.
Oh, I'm sorry, you're talking about the regulated signs. Sorry.
Yes, I'm talking
okay,
about the regulated
Yeah,
signs.
I'm sorry.
And so we're looking at the regulations that are applicable, and because you're not on Port Authority property, you're in the city of New York, and they're both regulations, we should be looking at the sign regulations, not to traffic regulations that would be applying once you're on Port Authority property in the tunnel.
Okay, but we're still trying to figure out what approaches are.
We're still trying to figure out what an approach
versus
is.
exit plazas. And so we have to go somewhere because nobody's telling us really what they are. We're just kind of guessing our way around this huge investigation.
Isn't it also an important distinction that it's using the word exit versus approach encompasses both entrances and exits, and so there aren't any directional guidelines there, and so that might be an important distinction that we're talking about two different concepts.
Well, but it doesn't, just to throw out, that one Port Authority rule definition actually distinguishes approaches from plazas.
Right.
So it calls them plazas, not exit and entrance. It says plazas, so that encompasses both. If you want to use that, if you're willing to use that definition. And the only reason I'm looking there is it's because finally someplace where the word plaza is used in a sentence next to the word approaches, so it's pointing to something and not necessarily for what.
And another important distinction, if the Port Authority drafters are lawyers looking at the enabling legislation and they're seeing, oh, we're not allowed to construct approaches to the Holland Tunnel. We don't really have, if they're interpreting that as we don't have authority over approaches as opposed to we got control over the approaches with the enabling legislation, wouldn't that be why they're making that distinction? Assuming that when they get control over the plaza and control over the tunnel in 1931, it was already constructed, and so the concern would be that they're sort of overextending themselves. Well, what if the plaza isn't the approach? What if we get sued because we're trying to regulate traffic in the approach, but our enabling legislation is only talking about the tunnel? So what do we do in that circumstance? But like I said, we're talking about sign regulations, and the issue of whether the zoning resolution would apply to the plaza is a very complex issue that isn't quite as complex when we're looking at how the zoning resolution applies to private property that has a sign that's within view of the plaza, that's within view of the entrance roadway above Broome Street. And this is the exact type of harm that the zoning resolution is trying to prevent. The fact that we have to go in Google Street View in the middle of the street in a dangerous area, and there's this glimpse 3 stories tall. If you're not in a convertible, maybe you don't see that. Maybe in 1998, you don't have any way of knowing. But does that mean that in 1998 that it was any less valid, that the sign was within view, just because you couldn't subjectively see when you drove through the tunnel, when you didn't have access along the entrance road because the police were stopping you, just because we couldn't know in 1998 that this sign was within view? Doesn't the zoning resolution allow us to update our understanding of when we have access to new information? Which I think that we've seen that there's at least a glimpse that the sign is within view from the entrance of the tunnel, and we're happy to provide updated information, and we respectfully request that you uphold our determination.
Thank you very much. Well, very well presented. Any question?
If I can just clarify with council on the within view issue. The reason that this board has recognized within view to be an objective standard is because some people in 98 may have been able to see it, and some people in 1998 may not have been able to see it under what you've shown us, assuming what you've shown us is correct. So being that person or imagining what it might have been like is only useful to a certain extent because we have this objective standard.
Okay.
Is that correct?
Yes.
Council, will you submit this presentation?
Yeah, we'll submit it. And is there any other information that you'd like about the pictometry analysis or the instructions for recreating?
So that you can, in case the appellant can't evade police traffic and so on.
Okay.
police regulations.
all
Okay.
right.
I don't know if there's any, yeah. Okay. Okay, so,
Can I ask, I'm sorry, may I
Yeah.
just ask a couple of questions? One is, can we get a copy of that presentation?
yes, he said he's going to
Like-
submit, yeah.
Soon, right away? Because one question I have, and I'm not conceding anything, I'm not conceding any facts, but what I'm not clear on is on that diagram that he showed based on the Google Earth view of the sign from that entry area just north of Broome. He had another diagram, which I didn't fully follow, with boxes and things like that.
Yeah.
Was that little, so basically there was just a portion of like the upper left portion that was visible from, I would just like if he has dimensions sort of explaining that, because then we can do our own independent analysis, but I'd like to understand what they believe to be visible from, because when I saw it, I thought that the wall was, it was just a small portion of the wall, and I didn't think it included the portion with the sign. So I would just like to have a better understanding of what the buildings department believes was visible from that roadway.
And then, and with respect to that, if indeed you essentially agree with what was seen either through your own Google investigation or ideally a more in-person approach if that's possible, the subject of within view and that fleeting moment of being able to see it was already dealt with by the board in 812A in 462 11th Avenue, Van Wagner. So you should look at that case because that's where, again, only a little piece of the sign was visible for however many seconds, and the board already determined that that counts as being within view. So.
Okay. Okay. Also, I don't even know where to begin. I mean, there was a lot to respond to. Obviously, we'll respond mostly in writing, but
We actually
I know
need
it's
to move on to the
okay.
next.
I just wanted to make one point, and that is, again, and I know that Mr. Steinhaus talked about this briefly, but Rule 49 was promulgated in, I think it was 2005. It was not around in 1998, so it cannot be the basis for notice to us since it wasn't even around then.
So then what
just
you
wanna
really should
clarify
be
that.
looking at, which for me was more kind of more interesting, was the including analysis, so that where it would be including things of like kind or similar characteristics. What? 1201. And then the other issue of how city planning characterized these access routes as having kind of a similar characteristic about adjacent property, having no access from adjacent properties. Take a look at those things, because those did exist in 1945 or in 1961 when the zoning resolution became our zoning resolution. So instead, look at that instead of determining about the applicability of Rule 49, because if that applies, then we don't really need to address whether Rule 49 applies to a pre-2005 sign, which would speed
Thank you
things
very
up.
much
Okay,
for
thank you very
giving
much.
us this opportunity, so
Thank you.
appreciate it. Okay.
Okay, thank you very much. Oh,
Schedule.
submissions, sorry,
Schedule.
I'm so like, yeah. So, where's I'm surrounded in papers and therefore, okay, here we go. So, I don't know how much time you actually need to do your investigation. It seems to me you need at least 2-3 weeks to put together analysis.
At least a month.
A month? Okay. So, say we're a submission on February 24th, is that too early?
February 24th, that's today,
Today's the 27th, I'm sorry, the 30th?
Okay.
You want another week?
Let's
March
do another
3rd?
week. Okay, March 3rd.
March 3rd. Then DOB, March 17th, is that good? Yes? And then, how much time do they, another week? 1 week. One more week response, so then you respond to DOB on the 24th of March?
Okay.
Unfortunately, what that does, though, in terms of, we might want to move this up a little bit, or give you another, you could respond on the 31st of March, because we don't have hearings the first 2 weeks of April. So then you could have 2 weeks to respond, and then we have a hearing on April 14th. Okay?
It's a lot of material.
Yeah, it's a ton to read.
Okay.
We're all becoming experts in the history of the Holland Tunnel, which is fascinating.
And also, I just want to confirm that if we have questions, we can call counsel's office,
Yeah.
just so we have clarification on what's being asked of us
Right.
and.
Yeah, why don't you just
Why
tell
don't
them
we,
it's archived?
right, we'll talk about all the resources
Yeah.
we're consulting.
Perfect.
DOB, you.
That's great.
We'll
things
do
we
that by
looked at.
email with all
We'll do it by
parties.
email
Okay.
copy, so everyone has a record.
Sounds good. Thank you very much.
Thank you, yeah.
I just to put everything into context here. I just wanted to mention, because council addressed the Crystal case, which dealt with the approaches to the Brooklyn Battery, what was going to be the Brooklyn Battery Bridge, and then it was all undone, and said that the purpose of and approaches for a tunnel is because the tunnel is subriparian, and so that's where the key is. It may be that this is the statement that the court made in that case. The case was decided in 1956, and there are other statements made in that case. But the point that I want to make is that when it comes to case law addressing some of these issues, the big question that I had, and I still have, is that if approaches are so important, and if these things all took place during all the years leading up to even 1963, when the last master plan was adopted, why wasn't Rule 4253 amended somehow in order to mention the word approaches? Just mention the word once.
Would have been great.
Now, the word approach is mentioned in the definition of street, as an aside, in ZR 12-10, and it's used in the context of a common use of the word approach. Approaching a building, I think, is specifically the language that's used in there.
But
nobody saw fit to take this word, give it a definition, plant it on the map, and I believe that this could have been done if the CPC wanted to do it. The fact is, they didn't. We can speculate about everything that happened from 1939 until 2015, but what was done is what we have. And that's what we need to be looking at, I believe.
Okay, no, that's fair, but again, I think counsel for DOB brought up some interesting textual references to Section 1201 and other places, so please, since you're the statutory construct expert, take a look at that statute.
We all have to make a living.
Right. Thank you. Thanks very much. Okay, sorry to everybody else. Yeah, can we take a 5-minute break? And then we'll get back to this and hopefully we can go further.
Yeah.
Before we pass out. Okay. It's really hard to hear your mic.
Make sure your mic is off.